Hi, I'm Bill Bronchick, and welcome to Webinar Wednesday. Today's topic is Dodd-Frank and its impact on seller financing in real estate. If you are a real estate investor or you deal in selling properties with owner financing or do small business or small personal or small real estate loans, this is a topic that is going to affect each and every one of you in a significant way, or maybe not, as we will discover. So, a little bit about me for those of you who are new to Webinar Wednesday. I've been an attorney since 1990. I'm admitted to practice in New York and Colorado. I've been a real estate investor since 1992, and I own and ran a title and escrow company for 22 years. I founded CARI, the Colorado Association of Real Estate Investors, in 1994. We had 4,000 members, 400 to 500 people at our meetings at the peak. And I served as president until 2013. I'm also now the president and founder of the Colorado Landlords Association. And I've done deals in New York, Colorado, Texas, Oklahoma, Arkansas, Indiana, Florida, and California. And over 1,000 owner finance transactions I have closed. So I have a little bit of knowledge when it comes to this realm of law when it applies to real estate investing. So we're going to cover today is an overview of Dodd-Frank, sort of the 360-degree view, the 10,000-foot view of it. We're also going to get into what's called the SAFE Act and compliance with that, penalties for non-compliance with either, exemptions from Dodd-Frank, prohibitions, and how it affects you in real life as a real estate investor. Because I kind of wear both hats as a real estate attorney and a real estate investor. There's the legal side, there's the practical side, and how do we marry the two and get through the regulations and still make money in real estate. So if you have questions as we go, please do pop them in the Q&A or in the chat, and I'd be happy to answer questions for you. So an overview of Dodd-Frank. Dodd-Frank is a federal law written by two senators named Dodd and Frank. You remember Chris Dodd and Barney Frank, after the real estate crash of 2008, decided that the banks were evil and we need to pass sweeping legislation that is the longest in length besides the Internal Revenue Code. So there's a lot here to sift through, and I've sifted through quite a bit of it. And it's still some things that are not clear in there, as I'll explain to you. But basically, it deals with the mechanics for financing, and specifically when we're dealing with, as a real estate investor, owner financing transactions to buyers who intend to live in the property as their primary residence within 1 year, which means it could apply to new builds or even raw land, as we'll discover a little bit later in the conversation. So it applies to a lot of different areas, but the specific areas that I'm going to cover is how Dodd-Frank applies to us as real estate investors when we're selling properties to owner occupants with owner financing. And that makes you, thank you, Bruce, that's right. But Frank was a House member. Thank you very much, that's right. Barney Frank, he's not alive anymore, I don't think, is he? I just remember he used to talk he had a kind of a speech impediment and talked kind of funny, but whatever. I didn't write the law. It applies to loans, owner financing. It also applies to if you're doing contracts for deed, which are still considered extension of credit, but not lease options in most cases, as we'll discover, not lease options. So lease options essentially are a landlord-tenant relationship where the tenant has an option to buy. That's not a financing tool in most cases, and I'll talk about the specifics of that a little bit later. So if you're going to lend to someone to buy a house who's going to live in there as their primary residence, which I would never recommend that you do, only lend to people for business or commercial purposes or investors. But more appropriately, if you're going to be selling to someone who's going to live in there as their primary residence with owner financing or contract for deed, or however you do it, or wrap, it's all considered within the realm of the Dodd-Frank federal law. So it's the same in every state, Dodd-Frank. The SAFE Act, as we'll discover, is a state-specific law. The rules are issued by what's called the Consumer Financing Protection Board, the CFPB, as amendments to Regulation Z and what's called HOEPA, which is the Homeowners Equity Protection Act, And those of you who have emailed me before and said someone wants to borrow money on their primary residence and take a mortgage against their property, and I would advise you not to do it, especially if they're in trouble, especially if they're in foreclosure. HOEPA will murder you. It's different if it's an investor. Commercial purposes, business purposes are different, but someone who's owner occupied, bad idea. It is not, and this is important for you to understand what Dodd-Frank is and what Dodd-Frank isn't. It is not a regulatory scheme. Dodd-Frank is not a regulatory scheme, meaning there's not an agency that is looking to seek out real estate investors and find out what they're doing wrong and then fine them, punish them, or imprison them. It's not a regulatory law. What it is, it's a civil private action for a borrower. It's a civil private, it's sort of like discrimination, right? Well, discrimination is a little different because you have state agencies that'll come fine you for discrimination in housing, or someone can sue you for discrimination. This is not a regulatory scheme where a federal agency is going to come down on you for violating the law. And that's kind of a good thing, but it is a civil action for a borrower. And typically it's going to be a defense to a foreclosure or a termination on a land contract, or some sort of proceeding where you're trying to get the property back, and then they hire a lawyer and then they counterclaim with a civil remedy under Dodd-Frank. Compliance is important and more on this in a bit, which we're going to cover. If you're not within an exemption, you must use what's called an RMLO. So if you're wondering what an RMLO is, it's a registered mortgage loan originator. That's someone licensed in your state by the state mortgage agencies as a registered mortgage loan originator, an RMLO. Okay. So the challenge here is that the SAFE Act, as we'll discover, also has requirements for RMLOs when you're doing owner financing transactions, and the federal exemption may conflict with the state exemption. So the general rule is you have to go with the one that's more restrictive, not least restrictive. Even though it's federal versus state, this is not an area where the federal government says we're the final say and states you can't regulate more. This is a situation where the federal government says, here's the minimum regulation. States, if you want to regulate it more, go ahead. So you got to comply with both federal and state rules when it comes to seller financing. So the SAFE Act is a state regulatory law. Each state has their own SAFE Act. Okay, so it deals with licensing for owner financing and other lending transactions. The SAFE Act is a federal law too that implemented in the states. It was a federal law, part of Truth in Lending, and it was implemented with state licensing. So if you sell with owner financing under state acts, you must be or use a registered mortgage loan originator. Now, each state does have exemptions, and here's where it gets a little tricky. For example, in Texas, there's a 5-deal-a-year rule where you don't have to be or use an RMLO. Colorado, it's 3. Last I checked in California, it was 0. But again, this is a state regulatory law. Now, I don't know who's counting, but in theory, a state agency could come after you under the SAFE Act and saying, well, you may be okay under the federal Dodd-Frank, but we're a regulatory board and we're going to fine you or cease and desist you, or maybe even get a court order to get you to stop doing this without a license, without being a registered or using a registered mortgage loan originator. Now, let's say you're in Texas where there's 5 deals a year exemption. Who is actually going to keep track of how many deals you did a year? Probably nobody, as a practical matter. But if you're prolific enough, if you're, building, let's say, mobile home parks and owner financing them, and that would be within Dodd-Frank and within the SAFE Act, and you advertise on TV, you might get a knock on the door from a state regulatory agency, just to see if you're in compliance with the SAFE Act. Because if you're doing 50 of them a month, then you've got something to worry about. But if you're doing 50 a month, you probably have a full-time RMLO on staff. So it's probably not a big deal. It's those of us that are doing more than 5 a year, like in Texas, or more than 3 in Colorado, or wherever you're doing them, more than the state exemption. There can be fines. There can be potentially imprisonment as well. I mean, but that would be after they told you to cease and desist and then got a court order, then you violated the court order, and then they throw you in jail. So there's a lot of steps that I wouldn't lose sleep over. Oh my God, I sell a property with owner financing more than 3 times a year in a certain state, I'm going to go to jail. It's just not the way it's going to happen as a practical matter. So if you don't comply, they could fine you, they could cease and desist and try to get a court order. They could refer it for criminal prosecution, potentially, depending on how bad you violate their regulatory scheme. But again, it's not going to happen right off the bat. You do 6 in a state that says 5 in a year, and you're going to get arrested and thrown in jail. It's not going to happen. So what are the penalties for noncompliance? For Dodd-Frank, the penalty is actual damages. So the borrower that buyer you sold to can sue for actual damages, can sue for statutory damages, which would include all the finance charges and fees that you charge. So if you charge points, they get them back. All the interest, they get it back. Any closing fees, they get it back. They also get attorney's fees and court costs. So it could be pretty bad. I mean, if you, and by the way, the statute of limitations doesn't expire on a counterclaim on one of these. So technically, if you sold on owner financing and violated Dodd-Frank, they would have X amount of years to sue you. That's the statute of limitations. But 10 years later, they don't pay and you sue them for foreclosure to get the property back, they could counterclaim at that point, even though it's beyond the statute of limitations, and get 10 years worth of interest back, all the charges and fees and finance and attorney's fees and court costs. So it can get pretty expensive. And, as a practical matter, if you did every deal out of a different LLC, or if you were in a series LLC, a separate series LLC, in theory, it's a civil claim would be limited to that series or that LLC. So I was talking to a guy in Houston. I was speaking at the local RIA, and I was talking to him about this. And he goes, "I don't care." I said, "Aren't you worried? I mean, you could get hit pretty hard." He says, "Look, I deal in $60,000 houses. I sell like 40 of them a year. So if someone sues me, I'll just give them the house. I mean, it's more expensive to comply than the 1 in 300 times that this happens. I could just give them the house. It's only a $60,000 house." And there's some sense to that madness if you want to go that route. But if you're dealing in California, $1 million houses, that's a whole nother ball of wax. The statute of limitations, by the way, is 3 years from the date of violation by the creditor. So that'd be probably 3 years from the closing date. The defense to foreclosure as a form of set-off is also provided. And after 3 years, the consumer can bring claims only as a set-off in defense to a foreclosure. I mean, they can't bring an affirmative case. I don't know who would want to bring an affirmative case and say, "You sold me a house on owner financing and I want to cancel it and get all my money back." I just can't imagine someone who wouldn't be grateful that they got the owner financing. There are special penalties, though, in Dodd-Frank for what we call high-cost mortgages, which I'll talk about in a minute. And let's talk about the exemptions first before we talk about compliance. What are the exemptions in Dodd-Frank? So everybody gets 1 free pass a year, okay? Only if you're a natural person, estate, or trust. So LLC is not in there. Corporation is not in there. If you are a landlord, for example, selling your property to your tenant with owner financing, well, let's say you're just an owner occupant and you're selling your home and, a buyer came along with an offer and said, "Will you carry $50,000 as a second?" And I go get a new loan. That would be exempt because it's an individual selling the property, but you only get 1 free pass a year. If you're an LLC in that scenario, selling to a tenant, you would not be exempt. You would not be exempt. You don't get the 1 free pass a year. So the question is, what do they mean by trust? Well, they said estate or person or trust. They probably mean your living trust. But in theory, people have put a property into a land trust and then sold it under the 1 deal a year exclusion. Okay. I don't know if that's going to fly. I can't guarantee that's going to fly. I wouldn't do it more than 1 time a year either way. You know, just put every property in a separate land trust and sell it and say I'm always exempt. I think you're going to get hammered really bad by a judge for that. So there's nothing explicit in the law that says, you know, what kind of trust, but I wouldn't do it more than once a year. Then we have the 3 deal a year exemption. So if you've used up the free pass as a person, or you're an LLC, you can do 3 deals a year as a person, estate, or trust without a registered mortgage loan originator. Okay, so this is going back to the licensing thing. If you're buying properties, however you buy them, and sell them immediately for owner financing or mobile home or whatever, or raw land if the buyer's going to live there and put a structure there within a year as their primary residence or as a vacation home. You get 3 deals a year under the federal statute before you'd have to use an RMLO. Now, that might conflict with the state. So if you're in Texas, for example, you can do 5 deals a year without using an RMLO, but under Dodd-Frank, you can only do 3. So if you did 4, you might be violating Dodd-Frank, which means if you sued someone for foreclosure, they can counterclaim under Dodd-Frank, but there's no regulatory agency that's going to arrest you because you haven't gotten to 5 yet. Does that make sense? All right. So if you're not in the 1 deal a year exemption, and by the way, the 1 free pass exemption, you can't do a negative amortization loan, and you have to make what's called a good faith attempt to qualify your buyer, which is meaningless. It's a free pass, as long as it's not a negative amortizing loan. The 3 deal a year exemption, which means you're an LLC, you don't get the 1 deal, or you've used up your 1 deal. You must qualify your buyer under an 8-part test, which I'll talk about later. Now, you don't need an RMLO if you do 3 a year. And the question is, people ask me all the time is, can I use a separate LLC and do 3 deals a year under that LLC and 3 deals a year under another LLC and just totally never use an RMLO under Dodd-Frank? And the question is, in the state licensing scheme, is separate entities, does each qualify for the example in Texas, the 5 deal year exemption? And the answer is, I don't know. This is too new. There hasn't been litigated much. I probably wouldn't risk it. Maybe you have an LLC owned by you, and then another LLC owned by your wife, and then a third LLC owned by 50-50. That gives you 9 deals a year under Dodd-Frank without using an RMLO. But as we'll discover, using an RMLO is not that big of a deal. The question is finding one that understands it and will do it is really the crux of the matter. So let's get into the 8-part test. And you must document your due diligence. You can't just say, well, I considered these 8 factors. You have to document them. And you can consider past rental history, which is really important, because if you rented to the person with an option to buy for a year or 2 and then converted them into an owner finance, you'd be much, much better off, because number 1, you have a history that you can go by as a payment history. And number 2, you get capital gains treatment because you've owned the property for a year. So those of you who buy and immediately resell an owner financing, that's a short-term capital gain, even though it's an installment sale. Okay, so it's a short-term capital gain rate. If you buy a property and then you hold it for a year or more and sell it to a tenant on a rent to own, and then convert it after a year and a half to a wrap or a contract for deed sale or an owner finance sale, then it's a long-term capital gain, plus you have a rental history to go by. So it's a very, very good idea to do that. The 8-part test, as we'll go over in a minute, it considers 8 factors. But there's only one guideline that Dodd-Frank gives you. So it says you must consider these factors, but the only actual strict rule that you must go by is a 43% back-end debt-to-income ratio, which frankly to me is very high. I know FHA does that, even worse than that. I personally go like a rental. So if a person makes gross $3,000 a month, then his payment can't be more than $1,000 a month, 3 to 1. 43 is more than 3 to 1. It's like 2.5 to 1. So I don't think that's a deal killer. I wouldn't even go 43%. But just understand that you must document their debt to income ratio. So the 8-part test, what's in the 8-part test? You have to consider these 8 factors: current or reasonably expected income or assets. Now, how would you prove that? Documentation, tax returns, W-2s, pay stubs, et cetera, et cetera. Current employment status, proof of employment. You do that anyway as a rental. The monthly payment on the proposed loan relative to their income and assets. The monthly payment on any simultaneous loans, which you'd have to do on the back end ratio anyway, really, because the back end ratio of 43% is principal and interest on the mortgage plus car payments, student loan payments, credit card payments, so forth. The total can't be more than 43%. The monthly payment for mortgage-related obligations like taxes and insurance and HOA. What other current debt obligations, alimony, and child support? And you got to document these things. And you can find most of this on a credit report, which you'd be nuts not to pull, even if Dodd-Frank didn't require it. The monthly debt to income ratio or residual income. So the monthly debt to income ratio is that 43%. And then their credit history. And again, pull their credit. There's no specific credit score that's required on or any guidelines on any of this stuff except for the debt to income ratio. So I would probably, as a business practice, come up with a written set of guidelines. And then if you use an RMLO, you give him those and he'll qualify the buyer under that and then print out an approval letter and all the disclosures that are required of a mortgage loan originator and under the mortgage loan disclosures. Some prohibitions. This is the sticky part. So if you're under Dodd-Frank, structuring a deal, unless you're in that 1 deal a year exemption as a person, state, or trust, you can't do a balloon. That's the most sticky thing with Dodd-Frank. So no premature payoff or maturity date. It's got to be a 30 or 20 or 15-year amortization, however you do it. Also, you can't do an adjustable rate for the first 5 years. So the interest rate must be fixed for the first 5 years and then can go up 2% per year for a maximum hike of 6% from the original rate. Now, you can't do a balloon, but if you wanted a balloon at year 5 or 6, it's very easy to get one. You say, okay, Mr. Buyer, your interest rate is 6%. After 5 years, it's 8. In year 7, it's 10, then it goes to 12. That's where it caps out. They're going to cry uncle and they're going to refinance, or they're going to sell the property. So if you want a balloon, you can effectively get one. You might even say if you pay off, earlier than 5 years, I'll give you a discount as a sort of carrot and stick. So you can sort of get a balloon if a balloon is what you want. For high cost mortgages and then higher cost mortgages, so the maximum interest rate is above market. And it's based on what's called an APOR, average prime offer rate, which right now is about 3 or so, give or take. So if you're selling a property on a first mortgage, if you want it free and clear, you can't charge more than 6.5% above the APOR, which is 9.5%. And that's, I don't know why you want to charge more than 9.5% anyway. On a second lien, which is a wrap is a second lien, you get 8.5 point markup. But again, you're not going to be charging people 11% interest. Okay. In high cost mortgages, you can't charge a prepayment penalty and there can be no default rate in the note. So wouldn't worry about it. We're not going to get into high cost mortgages because we're not marking them up that much. A higher cost, though, is 1.5 points above and 3.5 on a second above the APOR. So on a wrap, you don't want to be charging more than if the APOR is 3, don't charge more than 6.5% interest. If you want to get more cash flow, just raise the price. It's not that hard to do. And by the way, it goes by not the interest rate, but the APR. So if you charge an origination fee, for your mortgage loan originator of a point, then you got to figure that out on the truth in lending, what your APR is. So your APR, not your interest rate, can be no more than 1.5 or 3.5 on a second for a higher, and then 6.5 and 8.5 on a high cost loan. So again, you can have a higher cost loan, but you don't want a high cost loan, because then you can't do a lot, and the penalties are higher, and there's a lot more things you can't do. The practical reality. First of all, remember, this does not apply when you're buying something as an investor. It doesn't apply to buying. Dodd-Frank does not apply in any way with any kind of subject to, owner finance, anything when you're buying. It applies when you're selling to a buyer who does, it does not apply, sorry, when selling to a buyer who does not intend to live in the property as his primary residence, or when you're selling to an investor, selling raw land to a buyer who does not intend to build or move a mobile or cabin on there within a year. So if you're selling raw land on owner financing, you got to put something in your agreement that says they can't build, erect, move any structure, or camp out there, or do anything, as a primary or secondary or vacation home in any way as a residence for the first year. Just make sure you do that if you're selling raw land. Lease options are generally exempt because they're just lease arrangements with an option to purchase. Now, if you did a 30-year lease option with a tenant with a declining option price every year at the end with a dollar buyout, well, that's not really a lease option. That's really an owner carry. That's a land contract. But if you sell on a lease with option for 2 or 3 years, even if you give rent credits of 15 or 20 or 25% to induce them to buy the property, I just don't see any court calling that a financing tool. So I've heard people say, don't give any rent credits because then it could be financing and then it could be under Dodd-Frank. I just don't buy it. I'm just not buying into that. If you violate Dodd-Frank, again, it'll come up when you try to foreclose or evict a non-paying buyer as a defense. It's also not likely a buyer can afford an attorney who knows Dodd-Frank or will work on a contingency. Unless you're the person I described earlier who sells 40 mobile homes a month on owner carry, then someone will have 1-800 bad loan and some law firm will sue you and for millions. But if you're just buying and selling owner carries here and there, I just really wouldn't, even though you might be violating it. What are the odds you're going to be in court? What are the odds that they can afford an attorney? What are the odds this attorney knows Dodd-Frank? What are the odds that their judge is going to rule in their favor? Slim. It's a risk versus reward. If you lose less than 1% of the time versus comply 100% of the time. So if you're doing 20 deals a year, the cost of compliance might be more than losing once every 3 years. It might be. You just got to do the math. Now, I'm telling you to violate the law, ignore the law. I would suggest that it's not that hard to comply with Dodd-Frank. The only thing the only big problem is the balloon. If you have to have balloons, then you may choose to just ignore Dodd-Frank and suffer the consequences if you lose. I just haven't seen it happen a lot. I haven't even heard about it. I'm in the community. I just haven't seen anybody get nailed on this badly yet, but nobody, of course, wants to be the guinea pig. But again, I wouldn't lose a lot of sleep over Dodd-Frank if you're in the owner financing business, because I would try to comply the best you can. And if there's a technical violation, I'm sure a judge will take pity on you and say, well, it's not really fair. Someone gets to live there 10 years and get all their money back plus attorney's fees, because that's what I would say if I was a judge. It's not fair. Okay. All right. By the way, I cover all this stuff in my creative real estate financing course, which you can find on legalwiz.com. And there is a code you can use for a discount. It is WIZ, Wiz. That gets you 50% off. So go to legalwiz.com and use the code WIZ. Get you 50% off the creative real estate financing course, which goes over this in the course manual and in the videos, and of course goes into owner financing and wraps and lease options and all that other good stuff too. Okay. All right. If you have questions, pop them in the Q&A or in the chat, and I'd be happy to answer them. I also, if you need to reach me if you're in a business where you're going to be doing a lot of these, I do consulting on Dodd-Frank. It is a federal law, so I can do this in other states. So if you're you have a business model where you're selling owner financing a lot, you may want to set up a consultation with me. Costs money, but hey, as the Meineke Muffler man said, I think it was George Foreman, he said, you can pay me now or you can pay me later. So here's my email, bill@brownchecklaw.com, telephone number, and website where you can reach me for consultation. So if you have a question, pop it in the Q&A or on the chat there, and I'd be happy to answer your questions about Dodd-Frank. Dodd-Frankenstein, says Scott. That's excellent. Michael asks, what does an RMLO do for you that you can't do that makes it legal? Well, first, what they do is they underwrite the loan. They underwrite it, meaning they're going to take an application at 1003 from your buyer after you were under contract, which is contingent upon a loan approval. They're going to do the math to make sure that debt to income ratio fits and all the other criteria that you give the RMLO, like is there a minimum credit score? Is there a maximum debt to income ratio that might be less than 43% and that's too much for you? Or employment history and so forth. And then they're going to approve them, hopefully, if they could verify the information. And then they're going to print out a bunch of disclosures. And then you're going to have your buyer sign that at closing with all your other title company and so forth disclosures. Balin asks, how much do you think we should pay the RMLO to do the paperwork? Well, for a short time period, Colorado had no exemption under the State Safe Act. So I was paying a guy down the hall $500 to just pump out a bunch of paperwork. And I just gave him the stuff and he just printed it out. It took him about maybe 40 minutes. And I paid him $500 and he was more than happy. If you do it a lot, I imagine you can charge a point and charge it to the buyer because you're giving them owner financing. You're not charging them all the junk fees a bank is charging. So you can, originate a 1 point loan origination fee to offset the expense of that if the RMLO charges more than $500. Kevin asks, why is it so hard to find an RMLO? RMLOs are a dime a dozen, Kevin, but good luck finding one that understands how this applies to owner financing and is willing to do it. That is the complaint I'm getting from people in a lot of states. Now, I know I mentioned Texas. If you Google RMLO owner financing in your state, there are outfits popping up in Texas and California and other states that'll do it for anywhere from $500 to $1,500. And again, if that's too much for you, if you're doing a low-end house, then you just charge an origination fee to the buyer and add it to the APR. Mark says, can I assume Dodd-Frank does not apply to financing a mortgage to a non-owner occupant when my entity is selling the property? That's correct. It's only to an owner occupant. Are there any type of lease option deals where Dodd-Frank can be applied? It's not clear. I mean, Dodd-Frank applies to the extension of credit under Regulation Z. What does that mean? A lease is not an extension of credit. An option is not an extension of credit. But I think substance over form, the IRS has and courts have sometimes said that longer term lease options with declining option balances with a dollar buyout at the end are really just a financing tool. No matter what you call it, it's a mortgage. So what they call an equitable mortgage, which is not often the case. If you do a standard lease option for a year or two or three and give the buyer tenant some sort of inducement to buy by giving them some sort of rent credit if they buy, I don't see a court calling that a loan. Josh asks, does this law apply to me when it's not a purchase but a second mortgage on the owner's equity? No, if you're buying and giving the seller a second mortgage, you're the buyer. It only applies when you're selling. Are there any court cases related to Dodd-Frank? Any sample? What was the violation type and who won the case? On owner financing, I have seen not one reported case, not one yet. There may have been some threats of lawsuits that were settled, but I wouldn't know that because those don't get reported. Good questions, by the way. Richard asks, if I wish to do a seller financing deal in Illinois, can you represent me as an investor, prepare the paperwork and contracts? No, I cannot represent you outside of Colorado or New York, where I'm admitted to practice law. I can consult with you about your business practices, though, as it relates to the federal Dodd-Frank law, and provide you with some compliance forms and regulations and things like that that you can do in your business. So if that's what you need, I can do it. But if you need me to represent you in a particular deal, unfortunately, I cannot do that outside the borders of my state. Does Dodd-Frank apply to non-owner financing, just private mortgage to an owner-occupant? Yes, yes. Dodd-Frank applies to all lenders, but particularly it hit hard on community banks who lent to your local farmer who was self-employed, or someone who on paper didn't qualify, but somehow they made their payments and they had a history with the bank. That shut out a lot of those types of loans around the country. Dodd-Frank really killed a lot of opportunities for people, which is why I'd like to see it go or be modified in big form. With seller financing, if the buyer will use his LLC as a loophole to avoid Dodd-Frank. That's an excellent thought, and I've had more than one buyer have an attorney suggest this to get around Dodd-Frank. And I told him he was out of his damn mind if he thought that a judge would say Dodd-Frank doesn't apply if the buyer lives there and just buys under an LLC. That's ridiculous. That's stupid. So the answer is no. It's not the LLC being the buyer. It's the purpose of the loan. If the guy's living there, you can do an LLC. You can do a corporation in the Cayman Islands. It doesn't matter. The guy's living there for his primary residence, and that's the purpose of the loan. That's what it's going to be. Okay. All excellent questions. Got a few more. A free RMLO service for fellow investors. As a note investor, we use calltheunderwriter.com. Calltheunderwriter.com. Thank you for that. I appreciate that. Ronnie asks, what would you say about an installment land contract? I hold title until the deal is complete, and that is a financing tool, a land contract. So yes, that is within Dodd-Frank. Does the RMLO send out verifications of employment and other verifications as an underwriter? Yes, they should do that. They should do verifications of employment. The problem is when you get someone who says, I've got 30% to put down in cash. I'm a self-employed person. I haven't filed a tax return, though, for 5 years or 10 years. You can't sell to that person under Dodd-Frank. Now, I know they're infinitely qualified by putting 30% down. You all would agree with that. But if you can't verify income, there's no tax returns. Plus, if you have how are they going to ever refi if they don't file tax returns? So I guess there might be some lender who would do it, but I would, unfortunately, Dodd-Frank kills that scenario. It kills that scenario. Okay, all good questions. Thank you. I think I got to all the questions today. All good questions, by the way. Thank you very much so much for participating. If you'd like to learn more about creative financing, wraps, land contracts, lease options, and I also cover this in my course, Creative Real Estate Financing, you could find that on legalwiz.com and use the code WIZ, W-I-Z, for 50% off. And contact me at my email if you'd like to hire me to consult with you about your business practices and revolving around owner financing and compliance with Dodd-Frank. Thank you, everyone, for attending. Have a wonderful day and enjoy the rest of your week. This replay will be available on my YouTube channel, youtube.com/Bronchick, later on today.